In this series, we have been discussing key impacts of the new Virginia, Colorado, and revised California privacy laws that will be coming into effect in 2023. This segment focuses on how these laws will impact health data and healthcare entities, in particular, those entities that are regulated by HIPAA. In general, healthcare entities enjoy broad exemptions under these privacy laws. First, I'll walk through the data type exemptions. The CPRA, the Virginia law, and the Colorado law all contain a broad exemption for protected health information, or PHI, that is regulated by HIPAA. The CPRA contains a similar exemption for medical information that is governed by the California Medical Information Act, or the CMIA. The Colorado Privacy Act also has an exemption for information that is created by a covered entity for purposes of complying with HIPAA and information that is derived from or maintained in the same manner as PHI. These state privacy laws also contain a broad exemption for personal information that is collected as part of a clinical trial or research study involving human subjects that are subject to both the common rule or other similar research ethical guidelines. Finally, both the Colorado and Virginia privacy laws explicitly exempt PHI that has been de-identified under HIPAA. You may recall that there was an amendment to the CCPA, with AB 713, which made clear that HIPAA de-identified information would be expressly excluded under the law, as long as particular conditions were met. This amendment passed after the CPRA was on the ballot in California, which means that this amended text was not included in the CPRA draft. So there is still an open question as to whether the changes made by AB 713 will still be effective after January 1st, 2023. Now I'll walk through the entity type exemptions. Virginia will have a broad exemption for both covered entities and business associates that are regulated by HIPAA. The CPRA also contains a broad exemption for HIPAA covered entities and providers that are regulated by the CMIA. The current draft does not contain an explicit exemption for HIPAA business associates. However, we are still waiting to see how AB 713, which did contain an exemption for business associates, will affect the CPRA. The Colorado Privacy Act does not contain an explicit exemption that applies to HIPAA-regulated entities or business associates. But if you recall, it does contain data-level exemptions for PHI and similarly treated information. It's important to remember that just because you are a HIPAA-regulated entity, you may still collect information that falls within the scope of these laws. For example, you may collect information through analytics or via your website's Contact Us form that is not PHI and therefore not exempt from the law. Stay tuned for our next installment in this video series where we discuss how these laws treat sensitive personal information.